Welcome to today's Law Awareness Weeks at CDC 2020, The Law and Me, Stronger Together, organized by the Law Society, Pro Bono Services, and the 5 Community Development Councils, CDCs, supported by People's Association, National University of Singapore, Faculty of Law, Singapore Management University, School of Law, Singapore University of Social Sciences, and Singapore Corporate Counsel Association. I am Tara, your host for today's webinar on Divorce and You, Sharia. So, just some housekeeping before we get started. Relevant materials for today's talk can be downloaded from the handout section, which you can see on your screen. If you're using a mobile phone or a tablet, the icon should appear on the top right-hand corner of your screen. On your computer, you should see these icons also on the right. So please download these useful materials before the end of the talk. Feel free to ask any questions during the webinar. You can type them into the question section and click send. Your questions will only be seen by the organizer. We will do our best to address them either during the talk or at the end of the talk, where we'll have at least 15 minutes set aside for questions. Please note that the discussion and any material provided in this webinar is not intended to substitute or constitute as professional legal advice. So the last point, you should consult a lawyer if you require specific legal advice. So, with that done, let's get right into this discussion. With us today is Halija Muhammad. Halija is an experienced lawyer. The focus of her practice is family law in both civil and Syariah courts. She is also a part of Musawah, which is a global movement for equality in Muslim family. She has been involved in representations to Select Committee on several bills, including the Administration of Muslim Law Act, Women's Charter, the Penal Code, and Maintenance of Parents Act. Halija, thank you very, very much for joining us today.
It's my pleasure, and thank you for joining us today.
No problem. Looking forward to a great conversation. In today's webinar, what we can hope to achieve is to give you a clearer understanding of the laws surrounding both marriage and divorce for Muslims in Singapore. We will also touch on divorce proceedings under Syariah law, custody of children, and division of matrimonial assets. Halija, for the purpose of setting the stage, I will begin with a brief overview of the Islamic legal system in Singapore and its application. So the primary legislation or law that would cover would be the Administration of Muslim Law Act, or also known as the AMLA or AMLA. The AMLA regulates Muslim religious affairs and the framework of how Islamic law in Singapore is applied. The AMLA outlines the structure and authority of 3 Islamic institutions, namely MUIS, ROMM, the Registry of Muslim Marriages, and the Syariah Court systems. It is important to note that the AMLA only applies to Muslims, and the Syariah Court covers marriages, divorces, and inheritance issues. Halija, so some of us are in interfaith or mixed race marriages and would like to know whether Sharia law would apply.
Okay, let's go into some basics, about the laws governing Muslim marriages and non-Muslim marriages, So when there are 2 Muslims getting married, so the bride is a Muslim and the groom is a Muslim, the marriage can only be done at the ROMM, the Registry of Muslim Marriages. In other words, if a couple, if they are Muslims, a boy and girl, male and female are Muslims, they do not have a choice, no choice to marry under the civil system. I get sometimes some of my clients, right? Both of them are Muslims, and they say, for whatever reasons, we don't want our marriage to be governed by Muslim law. Can we go and marry under the Women's Charter, or can we go and have a civil marriage and then go to the Registry of Marriage? The answer is a flat no, no. As long as the groom and the bride, they are both Muslims, no choice, must marry under Muslim law. Now, Singapore, under the Women's Charter, where a couple is a mixed religion couple, so bride is Muslim, groom is non-Muslim, for example, or vice versa, they are allowed to marry. In many other Muslim countries, whether Muslim majority or Muslim minority, this is not allowed. But Singapore, we are very special. We are very broad-minded, open-minded, very inclusive. We say that Muslim and non-Muslim, they can marry.
Yeah.
But the marriage must be done under civil law. So the marriage will be governed by the Women's Charter, and the solemnization or the marriage certificate will have to be issued by the Registry of Marriages, not the ROM. Yes.
Okay. So as long as both parties are Muslim, even though they are different race, they still have to go under ROMM, the Registry of Muslim Marriages.
Oh yes, yeah. Because we can have Indian Muslim married to a Chinese Muslim, and all sorts of racial combination. But as long as both parties are Muslim, must be a Muslim marriage.
All right. And on that note, what other requirements are there for a Muslim marriage to be valid? And let's cover the topic of solemnization and eligibility of Muslim marriages.
Okay, first in Singapore, of course, we are talking about Singapore because I cannot advise on other countries. Number one, in Singapore, bride and groom minimum age must be 18. Below 18, generally for boys cannot. For male, no exception, 18 and above. But there is an exception for girls. So in certain cases where the girls, where the bride is below 18, you can get a permission to get married, but the registrar or the Qadi in the Registry of Muslim Marriage must do some sort of an inquiry to see why or why not this girl who's 17 years old or 16 years old can get married. But generally, 18 is a minimum age of marriage. Anyway, boys and girls below 18, they have no business getting married. They should be studying and in school. Not getting married. Then secondly, obviously both parties must be Muslim. I covered that. Secondly, the important thing is in Singapore, because the majority of Singaporean Muslims, we belong to the Shafi'i school, and under the Shafi'i school, there is a requirement that for the brides, you need the permission of your wali. Wali is an Arabic word for the next male, the male next of kin. So usually the bride's father, grandfather, uncle, brother, etc., etc. So you need this person to consent. Now what happens if the wali refuses to consent? There are a few cases where the father of the bride says that you don't belong to the same ethnic group as my daughter or my family. I am therefore not giving permission for you to marry my daughter. Or, for example, the wali says that you don't belong to the same social status as my family, so I'm not allowing the marriage. Then what happens? What happens to this couple, right? Both desperately in love, both want to get married, right? So what happens is the bride, she will have to make an application in the ROMM for the registrar or the Qadi in the ROMM to become her wali. So that person, the Qadi, if after he conducts an inquiry, he thinks that the objections on the part of the wali is not reasonable. For example, the groom not belonging to the same ethnic group, is not a reasonable objection. Or the groom not belonging to the same status social circle as the bride, this is also not acceptable opposition. So the Qadi will allow the marriage, and he will become the wali hakim for the bride, and so the marriage can go through. So these are among some of the requirements. The other thing is there is also a requirement for minus meaning if the bride or the groom or both of them, either one or the other or both of them, if below 21, there is a mandatory marriage preparatory course that they have to go through. I think this is a very, very good idea because, like I say, if you're under 21, you know, generally it's accepted lah. Under 21, still quite not so mature, not so ready to get married, because marriage carries with it a lot of responsibilities. It's not I love you and then we all ride into the sunset. No, it's not, right? There's all the issues of, you know, financial responsibility, commitment, etc., etc. So if you're under 21, generally the sentiment is maybe not so ready lah for marriage, so must go through a mandatory marriage preparatory course.
That's definitely a good initiative for younger people, especially when they're coming into marriage, for all the reasons that you've just said. So I guess what else will we need for the marriage? You know, we've covered the wali or qadi alternative. I believe the other requirements would be to have witnesses.
Yes, there will be 2 male Muslim witnesses. Because marriage is not a private affair between the bride and the groom and just the family. It's actually a legal status. And because it carries with it a legal recognition, right? There is a need, right? There is a need for some people other than just the bride and the groom to know about this solemnization. Hence the requirement for the witnesses. Because in the event, sometime in the future, one party or some other people say that this marriage is not valid or it's not properly registered, then at least we have third parties who were there to confirm what took place during the solemnization. So that is the reason for witnesses. Yeah.
Okay. So solemnization requirements will be the wali, the 2 Muslim witnesses, and mas kawin. Am I right?
It's not mandatory. It is not mandatory. It is more a cultural practice. Yeah, it's not. Yeah. Under strict Islamic rule, there is no requirement. Although in some countries, because they follow very, very strict classical Islamic jurisprudence, the mahar is compulsory. But in Singapore, it's actually a token sum.
Yeah.
It is it's a token sum. Sometimes it's a diamond ring. Sometimes it's a bangle. In the old days, during my parents' days, it's $25. In the 60s, in the 50s, it's more a token, a symbolic sum. Yeah. But the lack of mas kawin does not invalidate the marriage. So even if you do not have a mas kawin, as long as the other essentials, like for example the wali, the 2 witnesses, the minimum age, and is properly solemnized by a authorized person like the qadi, as long as those other essentials have been fulfilled, if there is no mas kawin, it's not a problem. The marriage is still a valid marriage.
Right, excellent. So now we've understood Muslim marriage requirements. Let's move on to getting out of a marriage. So the main focus of our webinar now, which is grounds of divorce under Islamic and Sharia law in Singapore. So Halija, the first topic we're going to cover is talak. Can you please explain what that entails?
You know, when we talk about Muslim divorces, right? One of the things that come into a lot of people's head, particularly non-Muslim, is this talak. You know, they think that, you know, there's been a lot of literature, there's a lot of drama. I think some years ago there's a very famous drama, you know, the talak, I think. So yes, this is one of the cornerstone of Muslim divorces, right? The Muslim man has the right to divorce his wife unilaterally. Yeah, doesn't matter what the wife thinks, right? The wife can be begging and crying at his feet saying, don't divorce me, don't divorce me. But if for whatever reason the husband say that I want to divorce you and I am pronouncing the talak, right? That would constitute a proper divorce. So in Singapore, some countries, they have got different rules, right? In Singapore, the husband can pronounce the talak outside of the Sharia court. In some countries like Malaysia, in some states, you can't. You should technically pronounce the talak in court. But here in Singapore, you're allowed. However, talak, that pronouncement of the talak will have to be validated by the judge in the Sharia court. So for example, last year, right, my husband, in a fight, angry and all that, right, talak me, yeah? And then my divorce hearing, because of the process, because of the procedure, right, is only concluded today in front of the judge in the Sharia court. Then the judge will ask my husband, did you pronounce talak on the 1st of December 2019, for example? Yeah. And then he said, yes, I have pronounced it. I fully intended to divorce my wife. And then the judge in the Sharia court today, right? Today, which is the 28th of October 2020, he will validate the talak, and then he will say that I am now divorced.
Okay. So this is something the husband can do, but can the wife pronounce talak on the husband?
Oh, very sadly, it is the unilateral right of the husband to pronounce talak. Yeah. So only the husband can pronounce the talak. There is, of course, a process where the husband delegates his authority to pronounce the talak to the wife. So it does happen sometimes in the Sharia court, right? Yeah. Where the husband, he doesn't want to pronounce the talak for whatever reason, yeah? Many variety of reasons. But he is prepared to delegate that authority to his wife. So he will stand up in front of the judge, Sharia court, and he will say this: I authorize my wife to divorce herself. So in other words, he says that I delegate my authority to divorce my wife to my wife. So he delegates.
But it sounds like this delegation is probably something that will only occur if it's a very amicable divorce, or if the husband just wants to get it over and done with. Moving on, what other ways can the wife pronounce, or can wife ask for a divorce? The next ground we would like to cover is Khuluk, if I'm pronouncing it right. Can you please explain what that would entail?
Okay, in Singapore, in the Singapore Sharia Court, and under the Administration of Muslim Law Act, which we have referred to just now, the wife, right, obviously she cannot pronounce the talak. Yeah, that talak, as I said, is the right of the husband, right? That right is not given to wives under Islamic law. So except when the husband delegates the authority to talak to the wife, where the wife then stand up in front of the judge, and then she says, I accept the authority to divorce from my husband, and I now divorce myself with 1 talak or 2 talak. So that's the exceptional cases where it's a delegated talak. Normally, a Muslim wife in Singapore, she has various grounds for divorce. You are right. One of it is khuluk. Khuluk is actually a divorce by redemption, yeah, where the wife actually, the husband doesn't want to divorce her, and she couldn't get divorced by any other grounds under the Administration of Muslim Law Act. So she can ask the husband, please release me upon me paying you a small compensation. Yeah, a small amount of money. That's why it's called divorce by redemption. You redeem yourself through a payment to your husband. However, don't run away and misunderstand that the woman is buying her marital freedom, because the payment that she made to the husband under the khuluk payment, the amount is very small. It's usually a token, it's a symbolic sum. So it's not as if the husband can sit there and then demand that she pays him 20,000, 100,000, 30,000, whatever. No.
Yeah.
The amount is a small token amount. Sometimes $50, sometimes $100, sometimes $20. It's a token, it's a symbolic amount.
And the court is the one which will determine this amount.
No, either the parties agree, right? The parties can come to an agreement, or the court can determine the amount. Yes, you're right.
So let's say, or if under Khuluk, if the request for divorce, and then she says, look, I will pay you that redemption or compensation sum, but then the husband says, no, I refuse. What other alternatives does she have? Would she have to go to another area of divorce, and then Khuluk is out of the question?
Yes. Usually when the wife seeks a divorce, right? One of the most common ground for divorce, is breach of taklik. Taklik is an Arabic word. It means marriage promises or marriage condition. So during the marriage, right, the husband makes various promises to the wife. And then if he breach any or one or more of these marriage promises, and the breach is proven in the Sharia court, then the wife will be entitled to a divorce by taklik. And the taklik in Singapore, it's printed in the standard marriage certificate. So no choice, the husband, whether he likes or he don't like, in Singapore, right, when he marries, during the solemnization ceremony, there will be 5 promises that he makes to his wife. So number 1, I promise not to fail to maintain her for more than 4 months. Second one is, I promise that I will not leave or abandon her for more than 4 months. Then the third one is, I promise that I will not cause physical injury to her. And then another one is the promise that I will not damage her personal property. And the final one is, I will not make her lose her self-respect. So these are the marriage promises the husband makes to the wife at the time of solemnization. And these promises are encapsulated in the marriage certificate. So if in the course of the marriage, right, he breached any of this, and this is proven, right, in the court, then whatever the position of the husband, the fact that he doesn't want to divorce the wife, right, the fact that he desperately still loves her, cannot live without her and all that, right, despite the fact that at times he physically abuses her, never mind. But if the wife can prove the breach, she will be entitled to. So that is one ground of divorce for a Muslim wife in Singapore. The second ground of divorce is Fasak. Fasak again is an Arabic word.
Can I just summarize Cerai Taklik again? So essentially, Cerai Taklik is those 5 reasons that's set out on the marriage cert, and if that gets violated or it doesn't get, the husband doesn't uphold his end of the bargain, that is when the Cerai Taklik can happen. Yes.
One thing I must caution, Singapore is a very cosmopolitan place, right? So we increasingly now, we see a lot of divorces which were not contracted in Singapore. So we have our foreigners who come and work here and live here, right? So for example, I have a couple who got married in Egypt, and then they come and live here and all that, and then the marriage broke down, right? So they want to get a divorce. They don't want to get divorced for whatever reason in Egypt because they've been here and all that. They want to get divorced in Singapore. So again, before the wife can ask for a divorce on the basis of breach of taklik, the court must examine the marriage certificate. Is there a taklik or not? In some other jurisdiction, there is no taklik. Then what does the wife do? She must apply for divorce on another ground, not breach of taklik, because there's no taklik in the marriage. If there is no marriage promises, there cannot be a breach. So
Yeah.
in cases when there is no taklik in the marriage certificate, the wife must ask for divorce on another ground, fasak.
All right. Can I just bring us back to Taklik in a Singapore context, because I think we've almost exhausted that particular topic. I've got a question from the audience here, which says that in the instance the wife does not inform the court that the husband has breached Taklik, will the couple still be considered divorced?
If the wife, right, is the person asking for the divorce, right, she must come to court and explain to the court she wants a divorce on what grounds. So if she doesn't want to tell the court about the taklik, right, because in other words, she's not using breach of taklik as a basis for her divorce, then she must ask for divorce on another ground. Nobody
Okay.
is forcing her to tell the court that there is a breach of taklik, right? It's her choice.
Yeah. Yeah. So she'll have to move on to one of the other grounds. So the next ground we're going to cover now is Fasak.
Yes.
So can you give us examples of Fasak that you have experienced in your practice?
Okay. Fasa is the Arabic word for judicial dissolution. In other words, it is a divorce, right, which is ordered by the court. You contrast this with talak, right? Talak is the husband. The husband saying, I'm divorcing the wife, not the court. Breach of taklik is the wife saying that you breach your marriage promise to me, and because your breach is proven, you are going to be divorced from me. So it's different, right?
Yeah.
But Fasa is the judge. The judge saying that even though the husband doesn't want to divorce the wife, even though there is no taklik, and therefore the wife cannot go on the grounds of breach of taklik, I am the judge. I am going to see whether the wife is entitled to get a divorce because she can prove the fasa. In Singapore, the fasa is, for example, the husband has been imprisoned for more than 3 years. Okay? Or he refuses to perform his marital obligations. What that means usually is the conjugal relationship. Or, for example, the husband has got a disease, right? AIDS or some other sexually transmitted diseases, which, you cannot expect the wife to continue to live with him if he is going to cause her to have problems, right, medically. Or, for example, he has a second wife and he doesn't treat the first wife and the second wife equitably. So these are some of the grounds of fasa in Singapore. So if the wife,
alcohol and drug abuse, adultery come under Fasak as well?
is no, drugs and alcohol is not specified as a ground for fasa.
Okay.
It is not, unfortunately. Adultery, it's hard to say because there is a clause in the Administration of Muslim Law Act which says that if the husband lives and cohabitates with another woman, maybe we can use that.
Okay.
But I have to say that generally, right, in practice in Singapore, we don't really use fasa. We normally go for taklik because, like I said, the majority of people who come to the Syariah Court to divorce, they got married in Singapore. There are that handful where the marriage is not solemnized in Singapore. Then you have to see whether you fit into one of the grounds for fasa.
Okay. Right. So I guess the most common grounds would be Cerai Taklik. And then anything else that doesn't fall under that would have to somehow come under Fasak.
There is also a procedure in Singapore, where if the wife cannot get cannot prove breach of taklik on the part of the husband, right? For example, he's a nice husband, he maintains her properly and the children, doesn't beat her up, etc., etc., and she has no grounds on fasa, but
Yeah.
she doesn't love him anymore, or she has fallen in love with another person, right? Yeah. So what do we do in this case? So her divorce application will not be dismissed by the judge in the Sharia court. The judge in the Sharia court will direct the parties to go through an arbitration process. The
Right. Okay.
Yeah.
So that's another one of the topics that we're going to be covering later, which will be part of the actual divorce proceedings.
Yes.
Yeah.
This was in answer to your question that if the wife cannot prove, cannot get a divorce by Cerai Taklik, she doesn't have any ground on the Fasak, right? Then what does she do? Is she stuck with this man she no longer loves, right? It's a hardship situation, isn't it? So there is another avenue in the Singapore Sharia court for her to get a divorce. So we will deal with that later.
Okay. Yes, yes. I've got a question from the audience here. It says, what happens if the husband is impotent? So if the husband is impotent, will that be a ground for divorce?
Yes, it is definitely a ground on the Fasak, i.e. he is not able to perform his marital obligation. So
the conjugal relations that you mentioned just now.
Yes, yeah.
Okay,
so there is a ground there. Yes. So don't worry. You can get a divorce if your husband is impotent. Yes.
Okay, what about divorces in less straightforward circumstances? What if the parties, got married under Sharia law, but then during the course of the marriage, one of them renounced Islam, and then now they're trying to get a divorce? What happens then?
Oh, that one is reasonably simple, yeah. So, husband and wife, Muslims, then husband decided to renounce Islam, right? So, what does the wife do? The wife will go to the Sharia court, apply for divorce under Fasak, because one of the grounds for Fasak is, right, if one party has renounced Islam.
Okay.
And you get you apply for a divorce even though one party is no longer a Muslim, right? So you would think that, oh, I go to the civil court. No. You have to go to the Sharia court because it was a Muslim marriage. It's just that after the marriage, one party renounces Islam. So you go to the Sharia court and you apply for divorce on the grounds that my husband has apostated or murtaded, as I call it. The word is murtad, right? So he murtaded, and then she can get a divorce.
Okay, I've got an interesting question from the audience here, where in the event that there is a marriage between a foreign, non-Singaporean, non-Muslim spouse, and then the Singaporean spouse is a Muslim, which has been registered in the Sharia court, can they seek a divorce outside of Singapore Sharia court?
Hang on. These are the facts,
Yes.
is it? Let me get it right. Non-Singaporean husband is a non-Muslim. That's in the question?
Well, yes,
okay.
That's in the question.
And then the wife?
And they is a Singaporean Muslim, and the marriage got registered in Sharia court, which wouldn't satisfy the
it will
marriage
not.
to be.
It will not. If the marriage is between a Muslim and a non-Muslim, it will not be considered a Muslim marriage. And if it's not considered a Muslim marriage, you cannot. The door of the Sharia court is closed. You cannot go. The door of the Sharia court opens only if it is a Muslim marriage or both parties are Muslim.
Regardless of where they might originate from.
It doesn't matter. I can have two UK nationals who are Muslims. They got married in UK, right? But say the husband has been working here in Singapore, right, for a while. They can get divorced in Singapore because they're Muslim. Parties are Muslims.
Yes.
Or marriage.
Right. Sorry to cut you off there, but I guess this leads into another question where if two Singaporean Muslims, they have a marriage, they got married in Singapore, can the wife apply for Fasak if she discovers that her husband has a second wife in a foreign country like Batam without her consent?
Technically, that is not a ground for Fasak, because the fact that he married, right, sort of illicitly, yeah, I use the word illicitly because technically, if a Muslim man in Singapore wants to contract another marriage, a second marriage, right, while his first marriage is subsisting, technically he must make some application in the ROMM in Singapore. But this guy did not. So he married a second wife illicitly in another country, right? It's not as uncommon as we think. It does happen. Now that by itself, that the second marriage in Batam per se, by itself, is not a ground for divorce under Fasak. It's not a ground. Yeah. But if she can prove to the court that by virtue of the second marriage, he failed to treat her, the first wife, fairly and equitably. In other words, he will spend 5 nights with the second wife and 2 nights with her. Yeah, that's not fair. Or he provides more for the second wife in Batam than for her and the children. So if she can prove that she was not treated fairly and equitably as the first wife, right, then she can get a ground for Fasak.
Okay.
Yes.
Yes, excellent questions. I think there's one more here. This is one I'm curious as well. Is there a minimum number of years that a couple have to be married before they can apply for divorce under Syariah law?
Oh, the answer is you can get married today and tomorrow you can go and apply for a divorce. Of course, that is an extreme example, but mind you, Tara, I have done cases and many other lawyers have done cases where they get divorced after 3 months, after 6 months, after 1 year. Yes, it does happen. I have one month. 2 weeks after they come back from their honeymoon, they start fighting and quarreling, and they said, oh, this is just not working out. And then one party run off and start to initiate divorce proceedings. So there is no requirement. I know under civil law, there is this thing we call the 3-year bar, right? Yeah.
Yes.
The 3-year bar, which is that you technically cannot commence a divorce application under 3 years of your solemnization, unless you fall within the exception. But for Muslim marriages in Singapore, no. Yeah. Tomorrow can get divorced. Extreme example, of course, yeah. But technically can.
Technically can, yeah. All right, so that now we've covered the grounds of divorce. Can you take us through the proceedings or the procedure for filing a divorce?
Okay, it's kind of long, but I'm just going to have to summarize, right? In the Syariah Court, right, the whole process starts, the whole process starts by filling up this thing called a registration form. This registration form is not a legal document. You go to the Syariah Court website, you click registration form, and then you fill up number of children, how many room flat, what's your educational level, why you want a divorce, and then attach a photocopy of your marriage certificate, children's birth certificate, and then submit it to the Syariah Court. Now, after you have filed the registration form, you will be asked to attend a mandatory, this is mandatory, mandatory marital counseling. So, in other words, they don't want you to rush and decide to divorce your spouse. Must go through marital counseling to see whether, whatever is the marital differences can be resolved and the marriage can still be saved. So if after the marital counseling, 1 session, 2 session, one party, one spouse still wants to proceed with the divorce, no problem. They will allow you to then commence divorce proceeding. But before that, if you have children under 21, it is compulsory. If the couple has children under 21, there is a mandatory parenting counseling. Yeah. so that
Mhm.
it's a good program, so that instead of focusing on themselves, right, the problem between husband and wife, maybe they can start thinking about, whoops, what happened to my children if I proceed with the divorce, right? Or
Yeah.
how do we co-parent, right? We are divorcing, but we remain parents. So how do we co-parent? So these two
Mhm.
programs are compulsory: marriage
Yeah.
counseling and parenting counseling. So if this is completed, then
Mhm.
one party can initiate the divorce proceeding. So
Okay.
after the last marital counseling, you have 6 months. The window period is after the last marital counseling, 6 months to issue a divorce summons. In other
Mhm.
words, they give you 6 months to really decide whether to proceed or don't proceed with the divorce. Yeah,
Yeah.
so 6 months window period. Now, if you exceed the 6 months window period, you have to
Yes.
start all over again. Fill out the registration
Mm.
form,
Okay.
go through the mandatory counseling, go through the parenting counseling, then issue the divorce summons.
Mhm.
Yeah. So this is the pre-action, pre-legal action steps.
Mm.
Registration form, mandatory marriage counseling, parenting counseling, and then after that, if you one party wants or both parties wants, the plaintiff, yeah, the person who starts, will issue the originating summons. Yeah,
So is this
originating
when a
summons.
lawyer comes in?
Yes. If you have a lawyer, this is when the lawyers step in,
Okay.
because the originating summons, yeah, and the documents for the divorce, they are legal documents. It is preferable if somebody who is legally trained prepare these documents. Of
Mm.
course, if you know how to do it yourself, you're intelligent enough, and you kind of know what the law is, you don't have to have a lawyer. You can complete all these forms yourself and submit it and file it in the Sharia court.
All right. Just to take a step back, we've got a question here about what happens if one spouse refuses to attend the mandatory counseling or the parental counseling. What happens then?
The person who doesn't attend the marital counseling or the parenting counseling, that person cannot be the plaintiff in the divorce. It's common sense lah. If he doesn't attend, it means that he doesn't want a divorce, right? So it is up to the wife. As long as she has attended the marriage counseling and the parenting counseling, right? And if
Mhm.
all steps have been taken to contact the husband and he refused, right? She can still
Mhm.
proceed, but she must have attended this.
Okay. So as long as one party has ticked off the boxes, meaning the marriage counseling, the parental counseling, even if the other spouse doesn't come, that spouse who has ticked off all those boxes can proceed to file for originating summons.
That's right. Yeah.
Oh, okay. So let's say, after originating summons have been filed, what happens next?
Let me just go back again to the divorce
Sure.
papers, the originating summons. There
Mm.
are documents. One of the documents is the case statement. The case statement, you will fill up the form about why you want a divorce, who are your children, whether you have any properties. So you need to tell the court what are your claims when there is a
Mm.
divorce, right? What is it that you want the court to order with regards to the children? What is it that you want with regards to the division of assets? Do you want 100% of the property, or do you want 50%, or etc.? And you also need to identify and specify what is the amount of mutaah or the alimony that you want. That's in the case statement. And then if you have children under 21, you are mandated to complete the parenting plan. You need to
Right.
tell
So
the
the
court what is your plans with regards to the
mm.
children.
So the
And then
parenting plan is only applicable to children who are a maximum age of 21 years old.
21
Just to
and
be
under.
clear. 21 and under. Okay. Right. That was one of
And
the
then
questions.
yeah. And the last document that you have to prepare is this. If you have a HDB flat, there is this thing called the property plan document that you have to fill up. Basically, you tell the court what is it that you want the court to order when there is a divorce. For example, you want the flat to be transferred to you, and then you refund your spouse's CPF monies that he had used. Or you want this HDB flat to be sold in the open market, and then after paying the loan, after refunding the party's CPF, right? How do you want the division? You want 80% of the profit, or you want 50% of the profit? These are just examples. So this
So
is
it sounds like this. Yes, sorry. Go ahead.
this is the third document that you have to prepare when you start the divorce proceedings.
Mm. So it sounds like it's essentially a roadmap or wish list of what sort of outcomes you are looking for out of the divorce.
And then, yes, and then for the other spouse, right? So for example, I want a divorce. So I prepare my case statement. I want $1 million from my husband as my alimony. I want 80% of the property. I want all our children under 21 to be in my care. So all these documents I prepare, and then it is served on my husband. He's the defendant. Now my husband, the defendant, is required to also prepare documents. So my husband will have to prepare the memorandum of defense. So he will then, in his document, reply to what are my claims. For example, I said that I want $1 million as alimony. So he will, in his memorandum of defense, say that, no, I'm only going to give you $50,000.
Yeah.
Right? Or I only think you deserve $10,000 because you're such a hopeless wife. You made my life so miserable. You didn't really do your duties as a wife. Whatever. So his position must be stated in his memorandum of defense. And then, of course,
Okay.
I said I want 80% of our assets. And then he will say, what do you think? Huh? I am the one who have put in all the money in acquiring our assets. Wow, you think just because you are married to me, after 10 years of marriage, you can get 80% of the assets? No, I'm giving you only 20% or 30% or whatever, right?
So let's say parties have both said their piece. So the plaintiff has filed, and then the respondent has filed his response. What happens next?
Okay, they will have to go for a compulsory mediation session. So at the mediation, as the word suggests, mediate, yeah? You negotiate, you discuss, you see whether the gap can be closed. Like in my case, right? I told my husband, you're a very rich chappy, you can give me $1 million for my alimony, you know? After all, I was your wife, right? And because of me, you succeeded in your career and all that. So you give me $1 million. And he said, no, I'm only going to give you $50,000. Okay, in that case, the gap is very wide. 1 million and 50,000, right? Very difficult to close the gap. But if, for example, the wife only wants, for example, $30,000, and the husband say, I think I can offer you $10,000, then we can mediate, right?
Yeah.
30,000 and 10,000. At the mediation, we can try and close the gap. Yeah. Or same thing with division of assets. I want 80% of the assets. The husband say, I think you should get only 50%. Huh? So we can close the gap, we can mediate, we can discuss. So that's what is the purpose of a mediation session. To see whether the husband and the wife can discuss what are their claims and see whether they can come to an agreement without the court, the judge, right? Stepping in and then making a decision which, you know, either party is not going to be happy with, right? Yeah. So that's the purpose of a mediation.
So let's say if mediation fails, what happens next?
Okay, if after our best efforts, right, we cannot mediate because the gap is too wide or one party is so stubborn or for whatever reason, then the file will go to a pre-trial conference. And at the pre-trial conference, if you have a lawyer, obviously your lawyer attends. If you don't have a lawyer, you still have to attend. That's when the court gives directions, directions on how to manage the case. Because remember, the husband and the wife cannot agree, right? So the court got to decide. So when the court decide, there must be basis for deciding. Cannot because I think wife very pretty, yeah. I think I give you your claim. Or husband, right? I think putting you husband, you have been bullied by your wife and all that. I'm going to give you your claims, right? So it cannot be on that basis. It must be a legal basis. So all the necessary documents, all the necessary information and evidences must be presented to the judge. So the purpose of the PTC is to tell the parties, with or without their lawyers, what are the documents that they must file and the timeline that they must file, so that at the end of it, the judge is in a position to decide what is the order that has to be made for the claims of the husband and the wife. So the PTC is actually directions given so that all the necessary documents, all the necessary steps can be taken before the judge is in a position to make a decision with regards to this divorce and the claims by both parties. Yes, that's PTC.
Okay. So at the end of the PTC, is that when they issue the divorce certificate and the
No.
decree?
Okay, after the PTC, right, all the directions have been given. So then, assuming all the directions were complied with, so all the affidavits, all the statements are in. When all that are in, then the court will give a hearing date. And
Okay.
on the hearing date, the judge will then decide again, first the divorce. Remember, just now I started by saying, if, for example, the husband has pronounced the talak, right, outside court a year ago or 6 months ago, then the judge will validate and confirm the talak.
Okay, so that's when, yeah.
Or if on the hearing date, the judge asks the husband, are you still prepared to pronounce the talak? Because initially at the mediation, you don't want to pronounce the talak, but your wife wants a divorce, right? So I'm asking you, are you prepared to pronounce the talak? If the husband is agreeable, fine. Then the divorce will be sorted out. If not, then the judge have to look at the evidence and see whether the breach of Talak is made out. Remember, if the wife is asking for divorce based on Talak or Fasak, the court have to look at the evidence, right, that is presented to the court. So if there is evidence, then the court can say that I have read the affidavit, I've looked at the evidence, I am persuaded that the husband has breached the Talak. I am therefore making an order that the wife is divorced by virtue of breach of Talak. So then there'll be a divorce based on breach of Talak, or because one of the grounds of Fasak has been fulfilled. So that's the divorce. Now, assuming the wife cannot prove breach of Talak, the wife cannot prove a Fasak, there's no grounds for Fasak, and the husband refuses to divorce her. That's where the judge will then refer the matter to arbitration. Remember, I alluded to this just now.
Was this Hakam that you were mentioning?
Yes, that's when the application is then referred to the Hakam process. And the Hakam, there will be two Hakam, yeah? Hakam is an Arabic word for arbitration. It's a little bit like mediation, except that the mediator, remember at the beginning of the proceeding, we have to go through a mediation process. Now, the mediator has no powers to deal with the divorce. If the husband said, I don't want to divorce my wife, that's it. The mediator cannot force the husband. But at the Hakam proceeding, right? Remember, all the evidence has gone in, right? The husband knows what is the allegations against him, etc., etc. So during the Hakam discussion, if the wife still wants a divorce, right, and the husband refuses, what the two arbitrators will do, right? There is one arbitrator for the husband, one arbitrator for the wife. Yeah, they are usually ustad, yeah, religious teachers appointed by the parties. So the two ustad, yeah, the two arbitrators will persuade the husband to pronounce the talak. You know, they will say, hey, look, you know, your wife doesn't love you anymore. What is the point of going through a marriage which is loveless? You know, you can't tango by yourself, right? You need two person to dance, etc., etc. So in a lot of the cases, the husband is persuaded to then voluntarily pronounce the talak. So in the beginning of the proceeding, right, in the mediation, he doesn't want to divorce the wife. After writing all the affidavits and all that, right, even on the day of the hearing, he doesn't want to divorce the wife. But in a lot of cases, after the two hakam have discussed and persuaded him to pronounce the talak, the husband then agrees to pronounce the talak. So
okay.
Now, if he doesn't want to pronounce the talak, the arbitrators or the hakam can persuade him to do the delegated talak. Remember, I talked about the delegated talak? Yeah.
Yes.
So the husband, in a lot of cases, he says, okay, I don't want to pronounce the talak, but I agree to do a delegated talak. Okay. And what happens if the husband, he is very obstinate, he's very stone-minded, right? Yeah. Nothing is going to persuade him. He doesn't want to divorce. He doesn't want to divorce, right? So what will happen in this case? Then the judge, parties were all the hakam, right? The two ustad and the husband and the wife will appear before the judge, and the judge will say, all right, since you don't want to pronounce the talak and you also don't want to do delegated talak, I am now ordering your hakam, husband's hakam, to divorce your wife. So the ustad, who has met this woman for the very first time in his life during the hakam discussion, will stand up and then say to the judge, I, Ustad so-and-so, the hakam for the husband, divorce Madam so-and-so, right, with one talak. So that way, almost inevitably, almost in 99% of cases in Singapore, right, the wife who asks for the divorce, when the husband refuses to divorce her, will invariably or inevitably obtain a divorce through this hakam process. So that's what will happen. So never mind that she cannot prove a breach of Taklik, never mind that she doesn't have a ground for Fasak, never mind there's no agreement on Khuluk. She will get a divorce through the hakam process, more often than not.
Okay. So let's say, we've gone through the hakam process, or alternatively, we've gone through the judicial process and a divorce certification has been given. Can parties appeal?
Sorry, Tara, I noticed that there is a question. Can the couple go back together after the talak? Am I allowed to answer this question?
Yeah, of course, go ahead.
Yeah. So what happens if they are divorced, right? On the day of the hearing, either through the husband pronouncing the talak or the wife getting a divorce through the hakam, right? Generally, the parties can reconcile. You can. To answer the question, can the couple go back together after the talak? The answer is yes. If there is an if, the divorce is by one talak or two talak. But if the divorce is by three talak, no, you cannot reconcile. Unless you go through a process where the wife marry another person, a third party, consummate that marriage with that man, and then divorce that man, then she can get back with that first husband. So under Muslim law, very generally, you can reconcile after the first talak. You can reconcile after the second talak. But after the third talak, 3 strikes and you're out. Yeah. So you then have to go through this process of the wife marrying a third party, consummate the marriage, divorce that third party, and then come back to family. You got to understand the rationale behind this is when Islam came, right, in 7th century Arabia, right, the divorce was totally uncontrolled. You can divorce your wife tonight and divorce your wife this morning and then marry her again tonight because you want to have a conjugal relationship with her. And this can go on ad nauseum. So Islam puts a break to that. You cannot dismantle the system, yeah? It's very, very difficult, right? When a religion comes, there is a social context. So what it does is it puts a break, i.e., be careful when you want to divorce your wife. We give you the first chance, you can reconcile. We give you the second chance, you can reconcile. But the third time, 3 strikes, you are out, yeah? Unless your wife goes through this process. It's actually a deterrence. So we need to understand the rationale for it. It's actually a deterrence, asking husbands to be very, very mindful. Don't anyhow, angry divorce, right? Upset divorce. Please be careful, be mindful, weigh very, very carefully whether you want to divorce by the 3rd talak because there are consequences. I hope I answered that question.
Yes, and it leads us to another question that's just been asked. It asks, how long does divorce proceedings usually take from registration until a divorce is pronounced or otherwise?
Okay, yeah, it depends. It depends if you resolve it at the mediation stage. Yeah, remember registration, mandatory counseling, issue divorce summons, attend mediation. If you manage to resolve it at the mediation, it'll be 6 months, 7 months. But if your divorce is contested because your husband doesn't want to divorce you, or even if he wants to divorce you, or he is the one who has pronounced the talak, but you all are fighting over the children, fighting over the alimony, fighting over the asset, yes, then it goes on. Yeah, it may go on for another year. So from the registration to the hearing date, be prepared, right? It can be 1 year, it can be 1.5 years. It depends on how contested it is. And whether there are delays, like, for example, you cannot find your spouse. So you cannot serve the divorce papers. Then you spend 3-4 months just trying to find him or her and trying to serve the papers. You got to take out application in court because you don't know where he is, etc., etc. But generally, 1 year, 1.5 years. Yes, I hope I answered that question.
Let's see whether another comment comes up. I think it's okay for now. So let's say that's all. The divorce has been finalized and all that. Is there any appeal that can happen?
Yeah. I'm very sorry. You were asking me about appeal, and then I looked at the question and I got sidetracked by the question.
That's all right.
Yeah, there is an appeal process. Yeah, the Sharia court is just the first level of the judicial system. If you're not happy, you think that the judge was very unfair to you. You feel that you should get alimony of $50,000, right? Because your husband is he can afford it, etc., etc. And then, but the judge ordered only maybe $25,000, so you're not happy, or you're not happy that the court makes an order on the division of assets, which you think you got too little, or conversely, the husband not happy because he thinks that the wife got too much. Yeah, whatever. If either party is not happy or both parties not happy, you have 30 days, 30, remember 30, from the day the judge made the order. So don't be dilatory, yeah, don't be tardy, please, right? If you're not happy, you must file notice of appeal in 30 days. Okay, 30. So be mindful, there's a timeline. And
right,
then,
so the time will run.
Yeah, the appeal will be heard by a higher court, and there are 3 judges. So the lower court, the Sharia court, only 1 judge, but on appeal, we have 3 judges. Okay?
Got it. So let's move on to ancillary matters. On the topic of children. So previously you mentioned the parenting plan and all that. So what factors does the court look at when they consider how to formulate the parenting plan?
Okay, generally, when there is a divorce and there are children 21 and under, yeah, there are three things that the parties must know, yeah, the husband and the wife who are divorcing. Three things, three orders that the court will make. Number one is custody, yeah. Custody is major decisions for the children, yeah, decisions on health, on education. Now the law is generally joint custody. So what it means basically is this: even if your children is in your care, they're living with you after the divorce, it doesn't mean that you can shut your husband out of the children's lives altogether. No matter how much you hate his face, right? He's still the father of the children. So that's why the order is joint custody, which means that even when the children are staying with you after the divorce, when it comes to big decisions, major decisions like the health, the education, you must consult your ex-husband. Yeah. So that's one of the orders that the Sharia court will make, joint custody. Now the second order that the Sharia court will make is, where is the children going to stay after this divorce? That's where the parenting plan comes in. They expect you, when you're divorcing, not to be so engrossed in your own problem as husband and wife, right? You focus, direct your minds on your children. Where are the children going to live? With whom? With you or with your ex-spouse? Yeah. So this is the care and control order. Now, generally speaking, young children, generally speaking, there are exceptions, yeah. Young children, they should be given to their mothers, generally. When I talk about young children 7 and under. But children 7 and above, when both the father and the mother who are divorced, right, they're fighting, both want the children to live with him or her, then what happens is, for children 7 and above, the court will interview and ask the poor boy, the poor girl, very poor thing, you know, they have to make a decision and tell the judge they want to stay with their mom or stay with their dad after the divorce. Yeah, generally speaking. Although the wishes of the children is very important, it's not the all and all. The court still can decide, even if the boy or the girl wants to stay with the father, but if on the evidence, the father is not going to be taking good care of them, probably the court will not grant care and control to the father. So it's just, I'm saying generally speaking. So that's the care and control. The third thing that the court will address their mind is this. So even if the children is staying with the mother after the divorce, the father will have visitations or access rights. So these are the orders that the court will make. Yeah. So usually minimum is at least once a week the father can see the children, and then there is they share the school holidays, and then they talk about access on alternate public holidays, etc., etc. So these are the general things that parties who want to divorce must be mindful. Joint custody, then care and control. The children are going to stay with father or mother. And then the last one is the non-resident parent. The non-resident meaning the children are not going to stay with that parent. What sort of contact or visitation or access rights will be given to that person? So generally, these are children's issue.
Okay, so apart from children, another matter of concern will be maintenance. We've already got a couple of questions on that here. So I understand that for the civil court, maintenance is usually granted. What happens in Sharia court? What about maintenance? What happens?
Okay, parties need to know that the Sharia court, right? When there is a divorce hearing in the Sharia court, the Sharia court does not hear maintenance applications for children. So if you are divorcing, or if after the divorce, you want to get maintenance of the children from your ex-husband, you cannot go to the Sharia court, right? The door is closed. You have to go to the civil court, the Family Justice Court in Havelock Road. Okay, so that's where you get your maintenance for your children, right? If there is a divorce proceeding in the Sharia court, or
Mhm.
after the divorce has concluded. I hope I
Okay.
answered the question. Yeah. So maintenance of
Yes.
children, not in Sharia court, family justice court.
All right. So we have a specific question here on this topic. Can alimony or maintenance for children extend beyond the age of 21 if they are special needs?
For children, generally in the civil court, right? The cut-off point, generally, I'm saying, is 21 and below. So if your child is 21, is 18 years old, but he is working on a full-time basis, you cannot apply for maintenance from the father. Okay? Because generally it's 21, but there are kids who are at 19, at 20, they have full-time employment. Or if above 21, right? But still pursuing a first degree. I mean, at 22, at 23, I was still a law student, yeah? So I don't have a way to support myself. Then the mother of that child, of that, not the child anymore, because above 21, but that, not the mother also, that person, the boy or the girl above 21 will have to go to the family court himself or herself, because he or she is no longer a minor, adult already, above 21. Then that person goes to family court and sue the father for maintenance. Okay,
So
to
what
answer your
happens if, yes.
special needs, to answer your question on special needs, yes, if it's a special needs child, you can still get maintenance, even though above 21, because the child is not capable, right, of fending for himself and supporting himself or herself. It's just like above 21, but still studying, you see?
Yeah.
Yeah, sort of same category, yes.
Oh, thank
I
you.
hope I
Thank you
answered
for
the question.
giving that excellent. Yeah, it was very it was excellent because you gave the background and all that to that question as well, and what the general considerations of alimony would happen in the case of children. Let's move on to the topic
For
of
children, it's not
nafkah.
alimony. Sorry,
Yeah.
Tara. For children, it's not alimony. Alimony is only for ex-wives. And
Okay.
alimony, that mutaah I was talking about, right? The amount
Yes.
of compensation that the wife should get after she's divorced, that is the Sharia court judge will order.
Okay.
But maintenance
Right.
of children is a separate thing. That one, civil court.
Got it. Got it. So for children's in a civil court, but for the wife, that's when the mutaah and the nafkah iddah comes into play.
That's right.
Can you give us a brief overview of what's nafkah iddah and mutaah before I have one particular question that addresses this topic?
Okay, before I go into nafkah iddah and mutaah, if I may, Tara, because we were talking about children, yeah, and I
Yes.
don't want to go out of the children issue. I see a question here, right? If the father is Muslim, does he get custody if the wife is a Muslim convert of another race? Okay, this is now this is becoming quite a common feature, right? Because they convert and then they marry, yeah. That's fine. And then the marriage broke down, and then in a lot of cases, when one spouse converts and then marry a Muslim partner under a Muslim marriage regime, right? And then when the marriage breaks down, when there is a divorce, that person who converted actually goes out of Islam. It's understandable, right? You can't really blame that person because in a lot of cases, I'm not saying in all cases, they converted because of the marriage. Of course, there are cases where they converted really because they believe in the faith, right? Okay, those are another category of people who convert. But in a lot of cases, when the marriage falls apart, the converted partner renounces Islam and goes out of the religion. What happens in this case, right? I don't know whether that is a specific question, but in this case, right, as long as that person, right, remains a Muslim, hasn't converted out of Islam, right, even though her parents, her brothers and sisters are non-Muslim, it doesn't mean that the care and control of the children will not go to her. Okay, so I give an example, and I've done many of these cases, right? A Chinese lady, right? She was a Catholic before, she converted to Islam, married a Muslim man. Then after like 10 years of marriage, the marriage fell apart. She did not renounce. She did not renounce, but of course she's gone back, right, to her family support, her parents who are Catholic, her brothers and sisters who are Catholic. So the fear of the ex-husband is, if the children are put in her care and control, she and her, maybe not her, right? But no man is an island, right? And then who are the people closest to us? Our family, our siblings. So the fear of the Muslim ex-husband is that the wife, the ex-wife, family members will influence the children to become non-Muslim. Yeah, that is the usual argument. Usually the Sharia court, if there is no evidence that the wife has renounced Islam, if there is no clear evidence that she is not going to bring them up other than as Muslims, right? She's not going to go and bring them to a church, right? Or teach them to believe in Catholicism, etc., etc. It doesn't mean that care and control of the children cannot be granted to her. Because if the Sharia court thinks that it is in the interest of the young children to be in the mother's care, the fact that she was not originally or a born Muslim is not relevant, right? If she will bring them up as Muslim, she will be a good mother, she will take care of their basic needs, their spiritual needs, their educational needs, right? Just because she is a Chinese, right, and her family members are non-Muslim doesn't mean that she cannot ensure that the children have a Muslim religious education. She can send them to the madrasah, the weekend lesson, she can make sure that they go for Quran reading classes, etc., etc. So I hope that answers the question. Of course, it's different if the spouse renounces Islam and then went out of Islam, and then there is evidence that he or she doesn't want to bring the children up as Muslim. Then the Sharia court will have to decide, is it in the children's interest to let the wife, who is no longer a Muslim, who will possibly not bring the children up as Muslim, to let the children stay with her? Then the answer is probably no. Yes.
All right, we've got an interesting question here where they said, what happens if I don't want to pay nafkah or mutaah? What happens then?
Oh, now nafkah iddah is not that important, because nafkah iddah is maintenance to the ex-wife for 3 months. Why 3 months? Why the magic 3 months? Why not 10 months? Why not 5 months? Because under Muslim law, if a wife is divorced, right, she cannot remarry for 3 months. And why 3 months? Not to make life miserable for her, because she cannot remarry in that 3 months. It's because to ascertain whether she's still pregnant, whether she is pregnant or not. Because obviously, if she's pregnant, we need to trace paternity to the ex-husband. That's why in that 3 months, she cannot marry. And because she cannot marry in that 3 months, the ex-husband is obligated to maintain her. So that's why we call it nafkah iddah, because the iddah is that 3 months period. So the nafkah is an Arabic word which means maintenance. So you got to maintain your ex-wife for 3 months after the marriage. Now the amount of nafkah iddah, it depends on the husband's financial position. This is common sense. If the man is rich, earns $10,000 per month, then maybe the nafkah iddah is $1,000 per month or $2,000 per month. But if the bloke is maybe of the lower income category, right? Maybe earn only $2,000 per month or $1,500 per month, then the nafkah iddah may be only $200 or $300 per month. Now, mutaah. That not the more significant issue is the mutaah, because the amount can be large. The nafkah iddah, because it's 3 months, it's not really that much lah, in the grand scheme of the universe. Yeah, but the mutaah, imagine if you're married for 20 years and the mutaah is usually calculated on the basis of per day of marriage. So if you're
there's
married
a formula for this.
Yes, 20 years times 365, you are married for 7,300 days. And if the court looking at your income, again, how much? It will be dependent on the husband's income, his financial standing. So for example, he earns about $5,000 per month. Yeah. So generally, maybe $5 per day. So if you're married for 20 years, 7,300 days, you times $5 per day, that comes out to $36,500. Yeah.
Okay.
And so on.
Yes.
So the law that you need to know is this: the amount is dependent on the husband's financial position, his actual income, his earning capacity, or is there any financial resources that he has, for example, from the net sale proceeds of their HDB flat, for example. Yeah. So the question that was asked is, what if I don't want to pay? Is that the question? I do not want to pay nafkah iddah and I don't want to pay mutaah. Okay, I have very sad news for you. Whoever asked the question, generally mutaah is payable. Yeah. Even, and this is where I think guys may not be particularly happy lah. Yeah. Even if it is your wife who wants the divorce, in other words, she's the plaintiff, even though you are a model husband, you are very angelic, you love her so much, you're financially responsible, you do not abuse her and all that, but she doesn't love you, right? Maybe she loves another man. Yeah. Even then, mutaah is payable. But on the basis of ihsan, it's an Arabic word which means compassion. Maybe instead of ordering $5 per day of mutaah, maybe the court say maybe $3, maybe $4. The amount may be reduced on the basis of compassion. Yeah. But zero, it's probably not going to happen. Yeah. So mutaah is generally, again, I use the word generally, payable. So the answer to your question is, what if I don't want to pay? You can don't want to pay, but the judge is going to order you to pay. Yes.
Okay.
So that's the simple answer to it. Yes.
Excellent. I think the next big item would be matrimonial property. What about the division of matrimonial property? And what happens if it's a rental accommodation?
Okay. Division of matrimonial property, unfortunately, we have 7 minutes to 8 o'clock. Division of matrimonial properties, I can talk for days, for hours, because it's such a huge topic, yeah? And this is one of the big contested issue in Sharia court, even in family court lah, yeah? After you are married, you go through this marital partnership, and then the marital partnership breaks down. So what happened to the marital wealth, yeah? What happened to all these assets that we have? Usually it's the matrimonial home lah, usually. But sometimes we are talking about other things. We're talking about shares, a Lamborghini. We're talking about a Swiss chalet, all sorts of things. But generally, the matrimonial home. The law is very simple. First thing, yeah, because I am running out of time, I will try and do this very, very quickly. Okay. 1, the court must decide what are the assets acquired by this couple during the marriage. Yeah. So all your CPF money during the marriage, all your bank account during the marriage, the vehicles, the club membership, of course, all the properties, if acquired during the marriage, all this goes into the matrimonial pool, we call it. And then after deciding what is in the matrimonial pool, for example, house, bank account, CPF, shares, then the court say $5 million. So the total wealth of this couple is $5 million. So then the court will say, okay, how do I divide this $5 million between the husband and the wife? The court takes into account many factors. Many factors. So the court, of course, takes into account who has paid for the property. Okay. So, for example, the wife is not working. So 100% of the purchase of the matrimonial home is by the husband. So what should the wife get? Yeah. Should she get 0? Should she get 30% or 30%, 50%? Yeah.
Can this also be applied conversely in where the wife is the one who's paying for the house, but the husband is not working?
Husband. Oh yes, or the husband is handicapped or whatever. Yes. It's gender neutral. It's gender neutral. So what the court decides is the court takes into account one, who has paid for the asset, right? Then number 2, what are the other things that the non-economic spouse have contributed? For example, looking after the children, looking after the house, right? Giving a lot of moral support to the husband so that he can perform well in his work. And then, for example, if the one property has been rented out and the rental has been collected, right, to pay for the mortgage of the current property. So there are many factors the court takes into account. They also look at the length of the marriage. The longer the marriage, the court will be sympathetic to the non-working spouse, right? Because the long marriage, 20 years, she didn't go out to work, she couldn't accumulate her own CPF money, her own wealth, so the court will be sympathetic to her. So there are many factors that the court takes into account, right? And then the court will decide to divide. I'm going to give the wife, for example, I'm just plucking a scenario where it's a long marriage, 30 years of marriage, the wife has raised all the children, right? Even though she contribute nothing to the assets, she will probably get between 40% to 50%. Yeah. So the non-working spouse contribution will be taken into account. Yeah. So generally 2 rules. First, we have to identify what are the matrimonial assets. So matrimonial home, right? Investment home, etc., and then decide what is the value. Then the second step is divide that aggregate value. Yes.
All right. Now I have a challenge for you, Khalija. Can you give us a brief overview of inheritance in the next couple of minutes that we have left? I know this is a whole other topic on its own, but can you give us a very quick summary?
Very quickly, right? Again, inheritance, I can talk for days and for hours, but very simply, in maybe 2 minutes, yeah? For Muslims, yeah? For Muslims, if we are generally Singaporeans, because the word in the AMLA is domicile in Singapore, so very difficult, legal mambo jumbo. But generally, Muslims who are Singaporeans, right, who stay here, if we die, we have no choice. Our estate will be distributed according to Muslim law. Okay? So if I'm a Muslim, I die, right? Whether I like it or I'm not, my estate will be distributed according to Muslim law. And for Muslim law, is a little bit different for non-Muslim. Yeah. For number one, Muslims cannot will away more than 1/3 of our assets. So for example, I die. I have $1 million of my estate. Yeah. Whether I like it or not, 2/3 of my estate will be distributed according to Faraid, the Muslim law of inheritance. I can will away 1/3. I can will away to my adopted siblings, my
so for
friend.
the 2/3 that cannot be willed away, how's the split between daughters and sons?
Generally speaking, right? Yeah, for the Shias is different, right? For the Muslims and the Shafi'is, yeah. Generally, daughters will get half the share of a son. Generally speaking. Yeah. And mothers, generally speaking, will get less than son. So for example, right? My husband dies, leaving behind me, my son and a daughter, right? My son will get the bigger share. My daughter will get half of what my son get, and I will get probably 1/6 of my husband's estate, generally
Right.
speaking.
Yes, so I guess to the audience on this note, because the distribution rules of Farid are extremely complex, there is a Farid calculator provided by the Syariah Court, which can help you gauge the amount that can be distributed. So if you go onto the Syariah Court website, there's an inheritance tab, and then there's an online trial calculation where you can put the various amounts and figures in. Okay, I think we're almost out of time. There are some interesting questions here. I apologize if I cannot get to all of them. Okay, there's one question here. What if the husband and wife divorce and the wife wants custody of the children but is not in good health? The wife has a critical illness like cancer, but at the same time, the father does not want custody of the children. What happens?
So husband and wife divorce, wife is kind of not able to look after the children, right? And the husband does not want. He doesn't want the children to stay with him. Unfortunately, the Sharia court will have to make an order on the children staying with either the father or the mother. So the mother, even because the husband, right, the father of the children, is not contesting the care and control of the children. So automatically, I think the care and control will be with her. She will need to get support maybe from her parents, from her sibling to care for the children. She will then go to the family court and make sure that the father of the children, her ex-husband, pays the appropriate amount of maintenance for the children in her care. So my advice would be to do that. Yeah.
All right. So we've got 8 minutes left for question and answers. Another question I've got here is, let's say, what happens if the husband cannot afford the mutaah? What happens then?
There is no such thing as cannot afford to pay the mutaah, because there will be some financial resources somewhere. For example, if the HDB flat is sold, and then there is some net profit. So, for example, the net profit is going to be, let's say, $80,000. Yeah, after we pay the mortgage, we refund back the CPF and all that, $80,000. And the court says that this $80,000 is going to be divided equally between the husband, 50% to wife, 50% to husband. So husband has 40,000, right? So what does he mean that he cannot afford to pay mutaah? He has got that $40,000 from the share of the net sale proceeds.
Right.
Right. So, or for example, he has monies in his CPF account, right? Although mutaah technically cannot be paid from the CPF account, we can word it such that the wife is entitled to a share of the husband's CPF monies, like as if it is a division of assets. So if the transfer of the CPF money from the husband's CPF account into the wife's CPF account is worded, yeah, in the court order is worded as the wife's share of the husband's CPF money, then we are okay. CPF board will allow it. So to answer the question that what if he cannot afford to pay mutaah, I think it's quite difficult to say. I have not come across a husband who is like totally zero, you know, nothing, no CPF money, zero bank account, no asset, a bit difficult. There will be money somewhere, yes.
Right. Okay, so can't get out of it essentially. An interesting one here. What if the Muslim person who passed away is of a matriarchal ethnic group, for example, Minangkabau, where the inheritance flows down the female line? And I remember just now we talked about, you know, inheritance, that it goes down, the females get half of what the males do. What happens if they are Minangkabau or matriarchal society?
I have not. Okay, this idea of matriarchal and Minangkabau in a modern context, yeah, in a modern secular urban society that we live in, this idea of You see, the idea of matrilineal and the matriarchal, it happens when we live in a rural agrarian society, right? Yeah. So now in an urban, modern, secular city state, I think it's going to be very hard pressed for you to argue that I come from the Minangkabau tribe and therefore it should be matrilineal, right? One, I think in a modern context, I don't know how far the court is going to accept that argument, because it's not consistent with the lived reality now. Yeah, that's one.
Right.
Secondly, I think the inheritance certificate do not talk about the cultural context. They talk about if you belong to the Sunni school. You know, the Muslims are divided into the Shias and the Sunnis, right? The Sunnis are 85% of the Muslim world. Under the Sunni school, we have the 4 different school of thought: the Maliki, Hanbali, Shafi'i, and something. Okay, so in Singapore, we are mostly Shafi'i. So when you submit your certificate of inheritance, right, you are asked to put the school of law. And if you are Shafi'i, right, they will just follow whatever is the computation according to the Shafi'i school. Or if you're Hanafi,
right,
they will follow the computation according to the Hanafi school. It's not a cultural thing.
Got it. Okay, that was a bit of an inheritance question, which we've sidetracked into. Let's get back into another question where, if let's say the house is solely owned by one parent, with the other parent having been deceased, but one of the children is staying in that house with the living parent, does the house have to be sold, or can the profits be divided by faraid?
Technically, right? Technically, if the house is in the sole name of the deceased, right, it has to be sold, because the other beneficiaries would probably want to get his or her share of that house. So, of course, if one party, okay, I have 5 siblings, right? My father died, right? Leaving behind this condominium in his sole name, and I have 5 siblings. I have 2 brothers and 2 other sisters. Sorry, 3 sisters. So long as one party, one beneficiary says, I want my share in father's condo, no choice. You have to sell, you have to liquidate, so that one person gets his share of the estate of my late father. Of course, the siblings can all agree, okay, we will not sell, right? We will not sell. We will let our sister, who has been living with our father, looking after our father, continues to stay in this property until whatever, until she passes away, or for another 5 years, and then we will sell. If the beneficiaries agree amongst themselves, the court doesn't step in. It's only when one party insists on his or her rights, right? Then we will have to liquidate. We will have to follow the division as per the certificate of inheritance.
Yeah, it sounds like the inheritance topic is a whole other thing that we can spend probably 1 or 2 other sessions covering. Okay, I've probably only got time for 2 more questions. The second last question is, what if one of the spouses renounce Islam? Does it mean care and control falls to the other party? And what if the Muslim spouse engages in abusive behavior?
Okay, there is a problem here, because remember, when the Sharia court decide, right, the children should stay with the father or the mother, it's a balancing act, and the only principle that the judge in the Sharia court is guided by is what is in the best interest of the children. Okay, so on the one hand, right, you have a non-Muslim mother, okay, but she is, for all intents and purposes, a good mother. And on the other hand, you have a Muslim father, but he is an abusive father. Okay, the abusers in this case must be quite extreme, lah. Yeah, it must be. It cannot be the little disciplining issues and all that. It must be extreme. Yeah. So in this case, I think the judge will have a problem, because how do I weigh, right, what is in the best interest of the child? It is not in the best interest of the child to be allowed to stay with a father who is systematically and a very abusive parent, right? But on the other hand, this child should be brought up as a Muslim. How do I do it then? It is a dilemma, right? There are 2 points of view. There are scholars, and I've read some articles, right, where the position is that as long as the non-Muslim mother or spouse, right, is prepared to bring the child up as a Muslim, yeah, then the child should stay with the mother because she's obviously the better parent. But there is that caveat. The child is a product of a Muslim marriage, right? You converted. You chose to convert. Nobody put a gun to your head to convert because you wanted to marry a Muslim spouse and you went through a Muslim marriage. The child is a product of a Muslim marriage. So we expect you to raise the child as a Muslim. So if you can give assurances that you will bring the child up as a Muslim, make sure that there's religious education, make sure that there's halal food, bring the child up as a Muslim. You may not be a Muslim yourself. Then you stand a chance in getting care and control of the child. Yeah?
Okay.
Because remember, the argument of the Muslim father is, you are not going to bring my child up as a Muslim, right? This is not in the best interest of the child. So it is, the judge is going to be put in a difficult position. On the other hand, there are scholars, right? Muslim scholars, which says that in a situation like this, no, the minute she renounced Islam, right, she automatically loses the right to care and control. The child must go to the father. So we do not know how the court is going to decide. It depends on the facts of the case. Yeah, I must qualify. What are the facts of the case? Yeah. In other words, if the father, it can be proven that putting the child in the care of the Muslim father is not in the interest of the child, not just abuses, other things, etc., 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 right? Then maybe he may not get care and control of the child. Yeah?
So it's really dependent on the facts of the case then.
Yeah, it's fact-centric. Yeah.
All right. So unfortunately, we have run out of time and I need to bring our question answer session to a close. There's so many questions and I'm so sorry I couldn't get through all of them. Hopefully we'll find another opportunity to answer all your questions, especially those relating to inheritance as well. Please remember that you can download resources and handouts on the topics discussed today, and these can be found on the Files tab on your screen. We hope that you found our webinar on divorce and Sharia useful. If you agree, tell us what you like, or if you disagree, tell us how we can do better. I promise we can take it. So we'll be very grateful if you could give us feedback on the survey that will be sent to you after this webinar. Thank you again very, very much, Khalija, for spending time with us today. On behalf of Law Society Pro Bono Services, thank you, the audience and everyone, for joining us today, and enjoy the rest of your day.
Thank you.